Hi, and welcome to today's Lunch and Learn presentation. My name is Terry Weber, and I'm with the UK Work-Life Elder Care Office. Today, our presentation is the importance of estate planning, and our presenter is attorney Lindsay Burke of Micah Legal. Micah? Lindsay,
Micah.
you're going to have to, Micah. Okay, Micah Legal. I don't know why I can't get that name. Lindsay is a social worker turned attorney. I think that's pretty cool. But she's also a Kentucky colonel. And do you know what that is? That is an honor awarded to those in recognition of their service to our community, to our state, and to our nation. Good job, Lindsay. Today's presentation, as we said, will be recorded. And if you have a question, please pop that into the chat box. After the presentation, I'll be sending out the YouTube recording to everyone and with a short survey. So if you have time, please take the survey. It always helps us to know for planning in future events. So without further delay, I'd like to introduce you to Lindsay Burke.
Good afternoon, everyone. I am Lindsay Burke. Thank you so much, Terry, for inviting me to present today. It is always a good day to talk about future planning, as I like to call it. A lot of people think about estate planning and say, gosh, I don't have an estate. I don't live at Downton Abbey. I don't have any reason to do any of that fancy lawyer stuff. But we all have a future, and using legal tools helps us address changing scenarios in our lifespan. So we all want to have control over our lives, and this is one way we can affect some amount of control over the many things that are out of our control. So I'm going to start off by talking about powers of attorney and guardianship, because even in the middle of your life, it's a good idea to have a power of attorney. So a power of attorney is about granting someone else the privilege of helping you with your business, financial, or health decision making. You are the principal. You're the person who grants power to an agent to act on your behalf. The attorney, in fact, is the agent who is charged with helping you with your affairs. In Kentucky, we have a durable power of attorney, and that takes effect as soon as you sign it, and it lasts until you become disabled unless you say otherwise. But there's also another kind of power of attorney that some people choose called a springing power of attorney. And that does not take effect when you sign it. It actually takes effect at some point in the future, either when two doctors determine that you're so sick or disabled you can't manage your own affairs, or you can set a specific time and date that you want it to take effect, or a specific purpose for which you want it to take effect. One example of that would be power of attorney only for the purpose of buying property. So sometimes you may be jointly buying property, and not everyone can show up to the closing. And so you want a limited springing power of attorney so that somebody could sign on your behalf. Guardianship is really similar, except you have less agency. So in guardianship, instead of being the principal, you're the ward. So just right off the bat, those two terms tell you there's a big distinction in how the law is viewing you. The ward is the person over whom the court has granted power. The ward may or may not lose rights to act on his or her own behalf. So contrast that with the principal who's in control, and I think we'd all rather be the principal than the ward. The guardian is an agent charged by the court with handling all of the ward's affairs. So that's similar but different to the attorney in fact. A limited guardian is an agent that only has certain powers, such as medical decision-making powers. And a conservator is an agent who only has financially related powers. So a conservator may be managing finances for someone who's unable to manage those for him or herself. Powers of attorney and guardianship are very similar. With a power of attorney, you can allow the attorney, in fact, to handle business or financial transactions for the principal, including the sale of property. And the same is true under guardianship. Under guardianship, the guardian or conservator can handle the sale of a business or financial transaction for the ward, including sale of property. if the court approves. Powers of attorney allow the attorney, in fact, to handle tax payments and tax disputes for the principal. And if a ward has tax issues, then guardianship will allow the guardian or conservator to handle tax payments and disputes. Under a power of attorney, the attorney, in fact, allows the attorney, in fact, to consent to medical treatment or the withholding thereof if it is also a medical power of attorney. And a guardian, on behalf of a ward, can consent to medical treatment and the withholding thereof. With a power of attorney, the attorney, in fact, can sue on behalf of or defend against a suit against the principal. And if a ward is sued, the guardian or conservator can defend the ward or can initiate a suit on behalf of the ward. And the last similarity I wish to highlight for you is that with a power of attorney, the attorney, in fact, is able to make gifts subject to limitations of the principal's assets. The same is true for guardianship, but only in the case where there is court approval. However, there are some important differences. Powers of attorney are granted by the person who wants help. So there is self-determination going on here. The principal has the ability to choose, nominate, appoint a power of attorney agent, and they're able to revoke that appointment. So if they don't like the way the agent is acting on their behalf, if they feel that the job has been adequately done and the person can be discharged, then a power of attorney can be revoked. I often tell my clients when we meet in person that I prefer the soap opera school of revocation. And by that, I mean holding up your power of attorney and saying, it's done, no more, please don't. But of course, it's always best to do it in writing if you're revoking a power of attorney. Powers of attorney don't require a court's approval, so that's handy. They create only limited oversight of an agent. So if the person you're appointing as agent, if you have any questions about their suitability, capability, or trustworthiness, then there isn't a whole lot of oversight over what they're doing. So that's something to consider. And powers of attorney don't require court fees, bonds, or bond fees. Now, with guardianship, those are granted by courts on behalf of someone who needs help. The court has to make a finding that the ward is legally disabled, and they do that by hearing the testimony, written or otherwise, of 3 interdisciplinary professionals, typically a doctor, a psychiatrist or psychologist, and a social worker. The ward may or may not understand or agree to the appointment of a guardian. Guardianships are also much more challenging to revoke or undo. They require court action to revoke or undo. There's also regular involvement with the court and much more substantial oversight of the agent, the guardian. Regular reporting is required. Typically, it's an annual report that must be filed by the guardian or conservator. And if you don't file those reports, you get summoned into court and made to do it. And lastly, with guardianship, there are a lot of costs. So typically there's going to be a court filing fee paid by the person who's seeking to be the guardian or conservator. That's going to run you around $100. Then there's someone called a guardian ad litem, or GAL. That's an attorney who's appointed to represent the person who we're calling a ward, because that person's rights are being potentially infringed. They are constitutionally deemed deserving of the appointment of an attorney to act on their behalf. If the ward is indigent or sufficiently poor, then the local government will pay that attorney to do his or her representation of the ward. But if the person is not very low income, then they would have to pay that attorney fee out of pocket. Then there are also bonds and bond fees. So guardianship can add up to be rather costly. And that's one of the reasons that doing a power of attorney before you're disabled is really a wise move. Some of the things you might think about when you're trying to decide if you want to grant a power of attorney or wait until guardianship happens. The first is timing and capacity or disability of the principal. If you don't get to this before your health goes south, then you may not be able to do a power of attorney. I can't tell you how often family members will call my office and say, hey, mom has just really not been doing well. Um, I know that she needs me to help with paying her bills. I think she can still stay at home, but could you make a power of attorney for me? And then I will say, well, I really need to talk to your mom about that. And then the family member will say, well, she really doesn't do well on the phone. And I'll say, well, could I meet her in person? And they might say, well, she's just not really good with strangers. And that's when I start to worry she may not have the capacity to give a power of attorney to someone else. Even though maybe a week ago she would have been able to do that. Unfortunately, when you fail to act, sometimes it ends up becoming impossible to do that power of attorney. Then you need to look at guardianship. So then another consideration is the trustworthiness of possible agents. The people you would appoint to be your attorney, in fact, need to be very trustworthy because you are empowering them to engage with your finances. You're giving them access to bank accounts, to Social Security, to the IRS, to retirement, to life insurance, all of these different financial things that you may or may not have set up. Your agent would be able to engage with them. And so you really need to think about, is that person good with their own finances? Do they have a solid head on their shoulders? Are they good with numbers? Do they know how to call and ask for help when they don't know the answer to something? Because you really want to be sure that the person you're theoretically handing the keys over to knows how to drive. You've put a lot of work and effort into setting yourself up for success, and you need to make sure your agent is committed and able to follow through on helping you with those plans. And lastly, you need to think about the proximity and willingness of possible agents. So this is something that I encounter a lot in my work. Families don't live as close together as they used to. We're not all on a family farm these days. And so lots of families are spread all across the nation and even the globe. And it may be that there are people who love and want to support you, but they just aren't nearby. So proximity matters because sometimes you really just need someone to show up and go to a doctor's appointment with you, or you need them to be able to come to your local bank branch and talk to the teller you've been working with who's raised some kind of issue for you. Proximity matters. And so sometimes that means you're choosing a niece or nephew to help you instead of your son or daughter. And also willingness matters because just like we're not all living close together, we aren't all living in harmony, sadly. And so a lot of times people are forced to choose an extended family member or a friend because their family isn't willing or able to help them. So these are some of the things you'd want to consider when you're getting ready to make a power of attorney in determining who would be a good agent on your behalf. Medicaid planning is another really important consideration for average and normal people. What's the purpose? So Medicaid planning is multi-purpose. It helps you save money on long-term care. Does anyone in this group have any idea what the average monthly cost of a nursing home in Kentucky is? You could put it in the chat or just shout out if you happen to know what the average monthly cost is. Okay, I'm seeing some really, really good guesses, and everybody's pretty much in the right ballpark. The actual average in Kentucky is $7,900 per month. And that's average across cities and counties, rural areas. And so here in Lexington or in Louisville, in the larger areas, sometimes those costs are more. And you may know also that there are limited numbers of beds. So when you're thinking about your long-term care and you're looking at the retirement accounts you have, money you might have invested in a home, what you have in your bank accounts, you've got to be realistic about, I think all of us want to age at home as much as we can. I think that's a really common desire. But what happens if your health doesn't allow that? What if your finances won't cover extra in-home care? You need to be prepared for those additional costs that might come with a nursing home, even if that's really not what you desire. So, how do you save money on long-term care? That's one reason to think about Medicaid planning. Qualifying for assistance without diminishing your assets. So, many of you know that if you don't do any kind of Medicaid planning, you may have to spend down your own assets, and that could leave you destitute at the very end. Accessing care in the setting of your choosing. I mean, that's what we were talking about earlier. Everybody wants to have some control, and so making these plans helps you to do that. Protecting your partner's income. You don't want your spouse or partner to be saddled with debt for caring for you that would leave them in a lurch for their own well-being. Maintaining your standard of living and ensuring your estate is distributed as you intend it to be. So that's protecting some of your money so that there can be an inheritance for that next generation, and avoiding family conflicts or legal disputes. How and when? So Medicaid planning often employs various strategies like the creation of trusts, the use of annuities, asset transfers to a spouse, and exemptions. You cannot do this without an elder law attorney. Your elder law attorney may assess your present income eligibility and secure Medicaid eligibility using a tool like a qualifying income trust. If you have a financial advisor, your attorney and financial advisor can work together to find the best way for you to pay for your long-term care and also preserve your assets for the future. I think it's extremely important that you find an experienced elder law attorney to assist you with this. And if you're interested in it, that you work on it as soon as possible. Because when you do this kind of work, if your disability comes too soon and you're in need of this kind of care, that can be a problem because you really need to get it done about 5 years before you need it. So I also want to just really underscore the experienced elder law attorney statement. Here's why it's important. If your documents are poorly drafted, everything can just become a total mess. And not only would you owe the government money, but you would owe your long-term care facility money, and then you're also going to owe lawyers money to clean up the mess. So it's really, really important that you work with someone skillful who does a lot of this so that no mistakes are made. There are lots of other tools that you could and should use. Living wills and advanced directives. Those tell your healthcare provider what your wishes are relating to life-prolonging treatment. They also allow you to nominate a healthcare surrogate who would communicate those wishes on your behalf to your healthcare providers. I have a link here, and I'm actually going to back out of this presentation and show you what is at that link. Now, are you all able to see that screen? No. Need to share a new screen. This is the Kentucky Living Will and Healthcare Surrogate Nomination Form. So the Kentucky Attorney General's office, starting with former Attorney General and now Governor Andy Beshear, created this living will directive and healthcare surrogate form that is designed for people to be able to use without a lawyer. And I think that's awesome. So I want to walk you through this form so that you're able to do that and have a loved one do that. This form's fairly straightforward, but there is one little tricky element. So obviously right here at the top, you're just going to print your full legal name, first, middle, and last, and your date of birth. The first section here is about the healthcare surrogate designation. So you'll check the box and then put your initials here and write the name of the person you want to talk to your doctors in the first and second blanks. So in my case, it would be my husband. I designate Spencer Mancilis as my healthcare surrogate to make healthcare decisions for me in accordance with this directive when I no longer have decisional capacity. If Spencer Mancilis refuses or is not able to act for me, I designate, and here is going to be a second choice. Let's say my sister, Emily Bryan. I designate Emily Bryan as my healthcare surrogate. Any prior designation is revoked. Now, this is an important clarification. If you don't designate a surrogate here, then you can still indicate directions to your doctor here. But if you have nominated a surrogate here up at the top, then this is telling the surrogate what they should tell your doctor. So there are three main decisions you make next. The first is about life-prolonging treatment. And in this case, life-prolonging treatment refers to, I'm not a doctor, so I'm going to use really non-specific terminology here, but ventilators, the machines that pump your heart when your heart is no longer pumping. These are the things that are keeping you alive, even though your body is not doing the job of keeping you alive anymore. So you are in a coma, you are unresponsive. And at this point in time, the doctors agree that if you are removed from life-prolonging treatment, you would die. If you have the feeling that you don't want to be on life-prolonging treatment and you do want to be allowed to die naturally, then you check the first box and put your initials here. If you want to stay on life-prolonging treatment as long as it takes for whatever amount of time, then you would check this box and say that you do not authorize the removal of life-prolonging treatment. It's written in a double negative, so people often make a mistake here, and that's why I really want to highlight this for you. The top box is if you want to be able to be removed from life-prolonging treatment, and the bottom box is if you do not want them to take the life-prolonging treatment away. The next decision point is about nourishment or fluids, because if you're in a coma, you're definitely not able to pick up a sandwich and eat it. And similarly, you're not able to take a sip of water when you're thirsty. So chances are you're probably already hooked to a feeding tube and you have an IV to keep you hydrated. And if you're lucky and having good care taken of you, someone's probably dabbing a little bit of water on your mouth to keep you from feeling dry. But what we're really talking about here is the feeding tube and the IV of hydration. If you wish for your family or the doctor to remove you from the feeding tube and artificial hydration, you're going to check this box and initial here. Or if you wish to stay on those feeding tubes and water tubes, then you choose the second box and check and initial. It's really interesting to me. I've filled out hundreds of these with people, and everybody's thoughts on these two decisions are very personal. You know, some people say, I believe in miracles. I believe I could be in a coma for 3 years and then wake up. And some people say, if I'm in a coma, my spirit's already gone. So those decisions are very personal. And even among people who want to be removed from life-prolonging treatment, I had this delightful woman say to me, I don't want to die of hunger. You know, I'm a really grouchy person when I'm hungry. And that's just not what I want for myself. So you can take me off life support, but please don't take away my feeding tube. And I love that she knows herself and that this document gives her the ability to make those decisions in advance. The third decision you could make is to allow your surrogate to determine what's in your best interest. I always try to steer people away from making this choice. This is essentially punting. This is saying, I'm not ready to make the decision. It's too hard. I want my healthcare surrogate to make that decision in the moment. And I understand this is a hard set of decisions to make. But at the same time, if it's hard for you, how much harder is it going to be for the person you're putting into that position? I wouldn't want my family members to wonder if they did the right thing. I want them to be able to know what my wishes are and to follow those wishes. So even if it's hard, they at least know that they honored my wishes. So I try and steer people away from this choice. If you make a decision up here, then you will not indicate anything right here. The final set of decisions through this document are about organ tissue and eye donation. And I think this is one of the most oddly specific lists I've ever seen. So you can be very general and say, I give permission for you all to use anything I've got that is useful to someone else. That's the first decision. Or you can be really specific about what's available and what's not. Or if you don't like the list they've given you, you can even write in what's available. And I'll tell you, I've had somebody write in, not my face, because they saw a movie about a face swap and they just really were disturbed by that. And they said they can have anything but my face. And so if that gives you peace, then that's what you should write here. Whatever you are willing to share, share. And if there's nothing you have to give, you want to take it all with you, then that's great too. So you would just leave it blank. I'm seeing a couple questions. Ms. McKee, you asked, how do you research finding a skilled elder care attorney in Kentucky? The good news is that there are a good number of them. Um, I would hesitate to name them here because I don't want to give the impression that any are better than others. But what I would recommend is using a combination of factors in your search. You can start with a basic internet search and just look up Elder Care Attorney Kentucky. Then you're going to want to look at reviews. And also, you could take into consideration looking to see if anyone has any issues with the Bar Association. The Kentucky Bar Association posts lists, so you can actually look someone up by their name just by typing it into the Bar Association website, and they would tell you if there are any major issues with that attorney. You can also, many of them do blogs or sort of online postings, and you can get a real sense of the quality of them by reading those things. And then I would also recommend doing a consultation. So after you've done some online research and perhaps even asked friends and family if they've got someone they've used, then I think a consultation is well worth your money because it's really important that you get comfortable with the person who's going to represent you because they are helping you with really big decisions and you need to be able to trust them. You need to feel just comfortable in their office and with them. They should be able to answer questions like, how many trusts have you created? And the number you need to hear is a big number. You don't want to be the 20th trust or even the 50th trust that they've created. You probably want to be at least the 100th and even better, the 1,000th trust that they've created, because that's how you know that they have the requisite skill and they've worked out all the details to make your documents just right. I hope that helps, Ms. McKee. And then Ms. Merkin, I see that you're asking about writing in qualifications. And I think you're referring to the living will. So on this specific document, the one that's created by the Attorney General's office, no, you can't write in qualifications, but it's possible to create a living will that is not part of this packet, and you can do qualifications with that. Now, what you listed as qualification examples are after 2 weeks. So that one would make sense and it could be written into a specially created living will. But the other is a determination that any recovery is impossible. And your living will does not come into effect until two doctors are already in agreement that recovery is impossible. So if they think that, staying on life support for 4 months would allow your brain to heal from the catastrophic injury you received, then they wouldn't be considering taking you off of life support. So that one is implicit already in the use of the living will. The doctors are already in agreement that the only reason you're alive is because of the life support and that you would not make any recovery, even if you stayed on it. So I hope that is helpful. And then Pam, I see your question and I honestly don't know the answer. That's definitely a medical question. Um, I don't have the right training to answer. I'm not sure if you've had a bone marrow transplant, if that impairs your ability to be a donor. I would love to know the answer to that. So I hope that if you figure that out, you can relay it back to the group because I think that would be great to know. So after you filled out the organ donation section, and actually let me point this out. Pam, if you have been the recipient of a bone marrow transplant, you could still check this and say that you consent to it, and then it would be up to the medical professionals to determine what, if anything, is usable. So I think you can indicate your willingness and understand that just because you say you're willing, it may not happen. Then the last thing you have to do to make this effective is to sign and date. So most of you will find this straightforward. You'd write in, if you were doing it today, the 17th day of September 2024. This is kind of funny. You have to sign small, little signature, because you have to also print your home address in the rest of this line. So you got to sign little and then print your full home address, Lexington, Kentucky, 40507, or wherever you live, all on this one line. Now, if you have a notary present when you sign, then they notarize down in the bottom, but that doesn't have to be the case. You can have two disinterested witnesses sign and write their addresses here to avoid needing a notary. But what I'll tell you is that that should not be the person you're naming as a healthcare surrogate. It should not be a family member, ideally. So this could be a friend, a church member, a neighbor, really anyone, provided that they don't stand to benefit from your demise. So it should really be someone that you're not related to, but who knows you and trusts you. It could be a stranger too. But this is an option in case you don't have the ability to get to a notary. So that is the living will form. And here at Micah Legal, we never charge for living wills because this packet is available online. And I did share with you the link here in the slideshow. The next document that you might want to create or use is a HIPAA release or disclosure form that gives your doctors and healthcare providers permission to release your protected health information to a specific person. So I think we're all fairly familiar with HIPAA, having been to doctors' offices and had signed this and signed that about understanding how little information they can actually share with other people. But as you start to age, it makes sense to set that up very clearly, who you want your doctors to talk to and when. So at our office, we include a HIPAA release in our power of attorney. We put together the business power of attorney with the health power of attorney and a HIPAA release all in one packet. but you can find these HIPAA release forms online, and they're almost always available from your doctor or hospital. So even if you don't consult with an attorney, you can get that release and fill it out and give it back to the hospital or doctor's office. That's really important so that there's never a point in time where you're so sick that you can't communicate about your health and your family is unaware. Uh, Another tool you can use, we've talked briefly about this, is trusts. Trusts change the ownership of your property while you're living. Generally, that's what they do. Um, Trusts are not a tool that everyone needs. They're more of an advanced estate planning tool. There are, and I'm not exaggerating, there are dozens of kinds of trusts. So it's I mean, you could have a 2-hour presentation just on trusts. Um, because there are so many and they're so complex, I actually don't create any trusts at my office. When it's time for someone to have a trust, I have attorneys I trust, no pun intended. Oh, I'm sorry, you're not seeing the slides. Let me make sure you can see. Let's get these back up. Did that fix it? Okay, great. Thank you, Terry.
We're back up. Yep.
Okay, so there are just so many different kinds of trusts, and they serve all sorts of different purposes. They can help you qualify for Medicaid, for example. They can allow you to avoid taxes. They can ensure that a minor child's money is spent on their behalf. They can prevent a loved one from wasting money that you give them when you die. There are just so many different kinds of trusts. If you are interested in learning more about them, then that would be something that you should do in a consultation with an elder law attorney. And the last and perhaps most practical tool is a last will and testament that directs your property disposition after you've passed away. In Kentucky, we allow for holographic wills, which I think is a silly and cool name, for just writing out your whole will in your own handwriting and signing it. That means that you can write it on a cocktail napkin, you can write it on a notepad, you can write it anywhere that you've got pen and paper. As long as you write the whole document in your own handwriting and then you sign it, it is legally effective in Kentucky. Now, that's not a common practice, but I've seen it happen and it was successful. Most people, though, choose to work with an attorney to draft a will. Wills guide the transfer of your probate property after you die, but not all of your property. So I want to distinguish for you what is probate property and what is not probate property. Probate property typically is something that only is titled in your name. So let's use a house, for example. If you are the only owner of your home and no one else's name is on the deed and no one else's name is on the mortgage and it's just yours, then that would be probate property because when you pass away, there needs to be a legal mechanism by which that property passes to someone else. But if you're married and you have a joint tenancy where both of your names are on the deed and it says with right of survivorship, and your spouse is still living when you pass away, then your house would not be probate property because the right of survivorship means that if husband dies before wife and they had a joint tenancy with right of survivorship, then the house just automatically becomes solely the wife's when the husband passes. The same with joint bank accounts. If you and someone else both have your name on a checking account or a savings account, then when one dies, the other receives that without it going through probate. Retirement accounts. are hardly ever probate property because almost every retirement account has a beneficiary designation. So that's one piece of advice I'd like to give you today. If you have a retirement account and you don't have a beneficiary, if it's an IRA, if it's a 401k, whatever type of investment accounts you have, find out how to put a beneficiary designation on them so that those can pass directly to the person of your choosing without them having to go through the probate process. You may or may not know that you can do the same thing with a checking account. Most banks have a document that they call payable on death designation or transfer on death designation. So POD or TOD. This is typically a one-page form that you would fill out in a bank to tell them, I have a savings account that's only in my name. And when I die, I want my savings account to pass directly to my son. And so you'd fill in your information, you fill in your son's information, and then all the son needs to do is take a death certificate to the bank, and then the account is directly transferred to him without the probate process. Let's see, what else is probate property? Not life insurance. That's another thing that goes directly to a beneficiary. So the more things you can keep out of probate, the better. And that means that jointly titling things, putting beneficiary designations on, um, doing transfer on death designations, life insurance policies, anything that you can do to keep your property out of probate is smart. Because the smaller your estate is on paper, your estate is the probate property, the easier it will be for your executor or your administrator to finish that probate process. A lot of people have asked me to put wishes about funerals, celebrations of life, and burials in their will. And a lot of attorneys do that. I don't. And here's why. Your will might not be found until weeks or even months after you've passed away. And by that time, your family or friends or whomever has already done a funeral, celebration of life, burial, cremation, whatever. They have had to deal with your mortal remains already. And I'm afraid for my clients that if we put those instructions into the will, that could actually set their family up to feel really bad if they don't find your will until later and they've done it wrong. So I make recommendations to my clients when they start their estate planning process to actually also write out their idea of what they want, whether it's big or small. Now, here at the church I attend, we have a pastor whose job is all the life transition stuff. So she's there for new babies at the hospital, and then she's there when people get married, and she's there at people's sides when they're nearing the end of their lives. She has a packet that actually helps our our members think about those decisions of what they want. And a lot of churches have something similar. But the internet's full of that stuff too. So if you don't want to talk to somebody about it, you could get a descriptive sort of walkthrough guide from the internet. Or if you do burial insurance or buy a funeral plot in a burial plot in advance or prepay your funeral in advance, then the company or organization you work with, they'll give you a worksheet too. And once you start to think about those things, the kindest thing you can do is to communicate those wishes clearly while you still are able to. It's a daunting conversation, and people really shy away from having those big conversations. But every single person I work with has told me that they've gone from the anxiety and worry place to the relief and gratitude place just like that. just by having that conversation that they thought would be so hard. And then after they're done, they say, I don't even know why I put this off so long. I just feel so much better knowing that my family knows what I want and how to take care of it. I am seeing a question from, um, wait, something about automobiles. Oh, Ms. McKee, I think you were probably talking about transferring automobiles. Uh, if both people's names are on them, then the title will transfer. And if they are not both listed, then you'd have to put that through probate. So yes, that's right. Pam, I see you asking, how do we keep nursing homes or Medicaid away from taking one's life insurance? That is the kind of question that you really need to have a consultation with a skilled elder law attorney. There's no short answer to that question. That is a 30-minute discussion. Um, so we've talked about probate property and the goal of trying to keep your probate estate small. We've talked about sharing your wishes. And let's talk about what happens if you don't make a will. So a will gives you a little bit of control over what the very end, um, after you've died, looks like in terms of your property. But if you don't make a will, then Kentucky has a process, a legal process, by which they determine who would be the recipients of your property. So the first thing that would happen is that someone has to tell the courts that you've passed away and go to file to become an administrator. An administrator is the same thing as an executor, except that's what you're called if there is no will. So you go and apply to be the administrator. Now, typically that would be a family member, or if the family is really limited and not able to, perhaps it could be a creditor. I mean, it's a sad but real thing. Sometimes people die with very big debt, and the creditor may apply to be the administrator so that they can potentially be paid back. So someone goes to apply to be the administrator. Then the court charges that administrator with finding the nearest living relatives. And I should have provided you with this diagram, but the court looks in both directions, up and down your familial line. So first they look for a spouse. If there's a spouse, that's the go-to person, but they also would divide your property between your spouse and children. So let's say that you're married and you had 3 children. Your spouse would take 50% of your estate, and the other 50% would be divided equally among your 3 children. Let's say you only have 3 kids, but your spouse has also died. Then 100% of your estate would be divided among those 3 children. But the law goes way, way, way out because not everybody gets married and not everybody survives their spouse or has a surviving spouse. Not everyone has children. Sometimes you don't have brothers and sisters. Sometimes you don't have aunts and uncles. Sometimes it really has to be a very distant relative. And the law has a way of figuring out who that nearest living relative is. And the administrator's job would be to contact that person and find out if they wish to be the recipient of your property. Now, when you receive property under a will, it's not your responsibility to pay the debts of the person who's died. It's their estate's job to pay those debts. And so if the estate has the money to pay the debts, then they're paid, and then the beneficiaries share whatever's left over. Sometimes, though, the debts exceed what's in the estate, and then there are procedures by which that can be handled, and you can disclaim those debts and say, I'm sorry, but there's just not money to pay that. But with good estate planning, you don't find yourself there, which makes everything a lot easier on your family after you're gone. So I really think even if you choose to not do some of the advanced estate planning, the power of attorney, a living will, And a last will and testament are really helpful and easily accessible tools that give you good control over what happens while you're living and after you've passed. Mr. Counts, I see your question. If powers of attorney were drawn up in another state, will Kentucky recognize it? Yes, they will. I can't say that it won't be without any bumps. There's some hesitation sometimes to accept powers of attorney that look different than what is easily recognized. And if your will is drawn up in, let's say your will is drawn up in Oklahoma, but then you moved here and you have nothing left in Oklahoma, it would be a very good idea to update your will to be a Kentucky will because the requirements in each state are different and the procedures in each state are different. And so you want to make sure that it's easy and straightforward. My advice to my clients has always been, you don't need to update your will unless something so big has happened that if it were 1910, you would write a letter to your grandmother to let her know. So think about the huge life changes. You would update your grandmother by a letter if you had another child. So you'd want to update your will. You would update your grandmother with a letter if you moved to a new place. So you might want to update your will. Now, if you still have a foot in both places, if you're a snowbird, for example, and you've got a house in Florida and you've got a house in Kentucky and you go back and forth, then you're not going to have two wills. You're going to have one created under one state's laws. But with Florida, as an example, they require probate to be opened in Florida with a Florida attorney. So you could have a Kentucky will and it will have to be probated in Kentucky and Florida in that situation. So whether or not you need to update depends on whether or not you still have property there. So if you had a house in Oklahoma and a house in Kentucky, then you could keep the Oklahoma will. But if you've moved everything here, then you'd want to update it. And then Leslie, I see you're asking the best way to have a will notarized. Well, any licensed notary in Kentucky can do that. So there are mobile notary services that will come to you where you are. There are free notary services generally at the bank where you bank. The Lexington Public Library has free notary services. And if you work with an attorney, they're obviously going to provide you with a free notarization as part of your document drafting. So we've covered a fair amount of ground in a decently short amount of time. I want to give you 4 minutes left. Terry, I see your point about Social Security for the power of attorney. Yes, you need to designate a representative payee using the Social Security forms. They call it something different. And so specifically using the Social Security form will save your agent a lot of headache. That is a great example and definitely worth pointing out. Other questions, concerns, anything else that I could answer for you all?
You're right, Lindsay. This has been a lot of information. So I will also send out Lindsay's contact information in the email I'll send to everyone who registered for today's, along with the PowerPoint and along with the YouTube recording.